Good evening, I'm Dennis Ward, and this is Face to Face. Our guest this week is Cree lawyer and former Member of Parliament, Romeo Saganash. Romeo was first elected as an NDP MP for Abitibi, Baie-James, Nunavik, Eeyou in 2011. He decided to step away from federal politics in 2019. Romeo, thanks so much for being with us this week.
A real pleasure to be with you.
Let's start with the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP. You brought forward a private member's bill on this in the House of Commons back in 2013 for the first time, but your relationship with UNDRIP goes much further back. Can you tell us about that?
Yeah, sure. I think it began somewhere in 1984, 85, when our former ambassador to the UN, Ted Moses, as you perhaps know, the Cree had an ambassador to the UN, and that's when Ted Moses invited me. He said, we're going to be starting work on drafting the United Nations Declaration on the Rights of Indigenous Peoples. Why don't you come? So, and I've been there every summer since then, during the time that this process went on.
It's been known as at least 3 different bills, I think. Currently it's Bill C-15. Can you believe it's taken, well, I mean, having worked on it for almost 30 years, can you believe it's taken 8+ years in the House of Commons to get to this point?
Well, I'm not surprised. In fact, there's more than that. My 2 private members' bills before C-15, but prior to that, Tina Keeper introduced a similar bill when she was in Parliament, and I believe Denise Savoy from the NDP also introduced something similar. So this has been going on for a long time, and I think it's unfortunate because this was a major promise that Trudeau made during the campaign in 2015. I was in the campaign in 2015. I heard him clearly that this was one of his priorities, that he would introduce a government bill to adopt and implement the UN Declaration. And we're now 2021. It hasn't happened yet, and that's unfortunate. I think we're sort of running out of time, too. The first hour of debate happened not too long ago. I think the second hour of debate on C-15 will be happening next Thursday, if I understand correctly. So it's been taking a long time. But you know, and if there's a spring election, then there's no hope of this bill getting through even the parliamentary process, never mind the Senate.
There is, and we'll talk hopefully about that spring election in a bit here, but there is opposition to the bill from the Conservatives and the Bloc Québécois in the House. So why do you think that is? Well,
I did expect that from the Conservative Party. They voted down my first bill, 640 or 641, in 2014, I believe, after a debate on second reading. The Conservatives are known to oppose UNDRIP. They claim that FPIC means a veto for Indigenous peoples, and so on. So that's not surprising. The Bloc is a bit surprising because they supported Bill C-262, and C-15 is pretty similar to C-262. What's the change? I believe the wording in the preamble of C-15 that talks about systemic discrimination and hopefully systemic racism as well. You know that they've been uncomfortable with the notion that there's such a thing in Quebec as systemic racism. So I think that's where the opposition is coming from, unfortunately.
Yeah, and we just had a story yesterday. You know, members of the Quebec government definitely opposed to using the term systemic racism. Are you happy with the legislation C-15 in its current form?
Well, it is pretty similar to the core elements of C-15 is pretty similar to C-262. That's pretty obvious. The preambular paragraphs have been is more elaborate than C-15. It still rejects the different doctrines, racist doctrines that have been used by governments explicitly in C-15, as it did in 262. But I think the important thing is for legislation to acknowledge and recognize that instruments, international human rights instruments like declarations, have application in Canadian law. The courts have been referencing the UN Declaration in their decisions, and that's going to happen more and more. The different human rights tribunals have been referencing the UN Declaration on the rights of Indigenous peoples even before the UN Declaration was adopted by the General Assembly of the UN in 2007. So it's been used a lot, and that's going to increase with time.
You know, UNDRIP, as we say, has been around a long time and is an important piece of legislation, but there is also opposition from some grassroots Indigenous peoples. So why do you think there is pushback from some Indigenous people as well?
Well, I think one of the claims that I've heard over and over again that C-15 is just going to be a confirmation of status quo. There's nothing in Bill C-15 that refers to that in any way. In fact, the preamble rejects all of the past doctrines, racist doctrines that have been used against us. I think one of the good things that Bill C-15 will bring, and I mentioned that on this panel last night, is the fact that contrary to the Charter of Rights, we have nothing to protect Aboriginal rights and treaty rights in this country whenever a piece of federal legislation is being considered by the House of Commons. The Charter of Rights has that protection. Article 4.1 of the Federal Federal Department of Justice Act 4.1 talks about the obligation of the Minister of Justice to make sure that any legislation, before it is introduced in the House, the minister needs to make sure that the legislation is consistent with the Charter of Rights and Freedoms. We don't have the equivalent for Aboriginal rights and treaty rights in this country, and BC 15 will have that effect for future federal legislation.
I know I've seen some debate online between you and Russ Daibo, a former candidate for the National Chief of the Assembly of First Nations, on this. He calls Bill C-15 the White Paper 2.0. What's your take on that?
Well, I think there's nothing in the bill. I mean, I have a problem with people reading into the bill when the bill doesn't say that. I think one of the things that we need to differentiate between that discussion and what the contents of Bill C-15 is, that they have nothing to do. So reading more into a legislation when the provisions and letter and intent of legislation does not say that is problematic for me. I believe that what Russ is talking about is the past practices of governments, whether there be liberal, federal, even provincial governments, against Indigenous peoples, and the arguments that they brought forward time and time again for more than 150 years, especially before the courts. That won't change. And I agree with that. That won't change. They will continue to do what they've been doing against us and against Aboriginal and treaty rights before the courts, and continue to make cranky arguments about with those doctrines. It's no wonder why, and I've said this before, it's no wonder why in the Chilcotin case in 2014, the Supreme Court of Canada felt compelled to dispel those arguments by governments by saying that terra nullius has never applied in Canada. So they dealt with that argument in one phrase in the Chilcotin case. I gave the other example also for a long time in Quebec, and still perhaps happening today, but for a long time in Quebec, the Quebec government argued that the Constitution of Canada does not apply in Quebec because of its civil law tradition and because Quebec never signed on to the 1982 Constitution. The courts never accepted those arguments, but that will continue. There's nothing that will prevent them from making those arguments in the future, unfortunately. But at least we have a piece of legislation that formally and explicitly rejects those doctrines.
Romeo, much more to talk about here, but we do have to just step aside for a quick break, and then we'll continue the conversation here on Face to Face with Romeo Saganash. Welcome back to Face to Face. Our guest this week is Romeo Saganash, and we've been talking about UNDRIP. And Romeo, in 2019, the province of BC passed its own UNDRIP legislation. What are your thoughts on that legislation? Has it worked the way it was envisioned?
Well, I think the problem there was a misinterpretation of what UNDRIP means. When we say that UNDRIP has application in Canadian law. I remember Premier Horgan saying publicly in an interview that no, Bill 41 was meant for the future, not for the past. Well, I call that BS, and I called it out publicly because that's not accurate in terms of interpretation. Even before Bill 41, UNDRIP had application in Canadian law, including in British Columbia. So that was a misrepresentation, in my view. I think from now on, they need to be careful on how they interpret these kind of provisions and how international human rights instruments have application in Canadian law. Courts, in their impartiality, and judges in their impartiality, can refer to international law to interpret domestic law, and that's how it works.
Another wild card, I guess, in Bill C-15 being passed in this round of Parliament, you already mentioned, and that's the fact that we have a minority government that might not see this legislation passed. Is that a concern for you? Well, yeah, I definitely expressed that concern when back in December when the legislation was introduced. I felt that we were running out of time. I also mentioned that it seems to me, knowing that the parliamentary process takes time for these kind of bills, that I felt that the Liberal government was just pulling another Kelowna Accord because they know that we might go into an election and there won't be any time to consider for a final vote, Bill C-15. I'm hoping that we can go till the fall because then we'll be able to complete the parliamentary process. But I'm not sure. I'm not the one who's going to call the election at this time. That prerogative belongs to the Prime Minister. Romeo, you decided to step away from federal politics in 2019. What was behind that decision? Well, I think that 8.5 years in that kind of place where you have to listen to people questioning your fundamental rights, where your fundamental rights are always up for debate daily in that house. It was 8.5 years was plenty enough for me, and I think I've my contribution to these kinds of debates that we're having, and my contribution to the Missing and Murdered Indigenous Inquiry, Girls and Women Inquiry, and my contributions were sufficient. I calculated the other day that in my 8.5 years in Parliament, I must have considered, I considered 1,463 pieces of legislation. Wow. In 8.5 years. And that's only the Parliament of Canada legislation, because we do get legislation from the Senate as well, being proposed by the Senate. So it's got to be more than that. But it's a lot of work for people, and especially for people that are getting low like me. Well, I wouldn't quite go that far, but nomination meetings are taking place right now, and we have been seeing a record number of Indigenous people running in the last few elections. What do you make of that?
I think it's important. We've seen an increase in Indigenous participation as candidates, but also in terms of participation in the election vote. I think that's important. We definitely have a place in the House of Commons. We definitely have a role to play, although it seems impossible at times. But we do manage to bring about change in that colonial place. And I think it's important that we have more and more people participating in that process, which Article 5 of the UN Declaration allows for. Article 5 of the UN Declaration talks about our possibility to participate in the economic, social, and political processes of a nation state without losing our status and who we are. For instance, and I'll give just this example. When I arrived there in 2011, the first ask I had to the clerk of the House of Commons was, can I ask my questions in Cree? Can I do my speeches in Cree? And the response was, well, Romeo, as a jurist, you should know that the official languages in this place is French and English. That was a response that I did not accept that in 2011. I kept working on that issue. And today, any Indigenous person wishing to speak their language during the speech or during question period can do so without fighting for that right. That's a big advancement for Indigenous languages, that we can speak our languages in a place like the House of Commons. So there are a lot of things that need changes in that place. So I'll leave it up to others now to achieve those. But it's an excellent platform for any Indigenous person that knows how to use this platform. It's an incredible platform for a lot of things. You have access to media and different platforms across the country, and that's how I used it for 8.5 years, and it's up to others now to do it.
Obviously, that was a big moment. What are some of your takeaways from your time as an MP? The good, the bad, or the ugly?
Well, I think a lot of people remember the unparliamentary word that I used one time against Justin Trudeau. That was, at that moment, I felt exasperated by their attitude, saying one thing but doing exactly the opposite, not delivering on their promises and their important promises that still remain unachieved as we speak today. Clean drinking water, for instance. Housing is another one. The high cost of living in the north. There's a lot of issues that still need to be addressed in this country. But at that point, I was so exasperated by watching them say one thing and do another thing that I just said to my team, listen. When they told me I had a question that day, I said, well, I don't think I'll ask a question. I'll just tell them what I think today. And no one expected what I did. I didn't tell anybody besides the two seatmates, two ladies that I had beside me, just to warn them about what was coming. But otherwise, no one knew what was coming. And I'm glad I did it, because I think everybody at that point agreed with what I said. I had security guards at the airport in Ottawa stop me after going through just to say to me, someone had to say. And that was a good moment. But also forcing the debate on the missing and murdered Indigenous women and girls, that the Conservative government absolutely did not want. They refused to have a debate on it. So we found a way procedurally to force the debate, and I think that was one of the great moments in the House of Commons. We finally got the debate, and we finally got that moving forward. So there's a lot of moments like that. But I think one of the difficult task for me was to represent a riding like Abitibi, Baie-James, Nunavik, Eeyou, so diverse in terms of people, in terms of economies. I had 14 Inuit communities, 9 Cree communities, 2 Algonquin communities, and the rest of the non-Indigenous communities depend on resource development in that riding. So the balancing between the rights and interests of Indigenous peoples in that riding with the rights and interests of others, and there's a lot of jobs implicated in this, was difficult, but I think I managed well representing everybody in that huge riding.
Always the balancing act, and those are always huge ridings in the north. Romeo, we just got to step aside for one more quick break, and then we'll continue the conversation here on Face to Face with Romeo Saganash. Welcome back to Face to Face. Our guest this week is Romeo Saganash. And Romeo, you touched on that infamous speech there in the last block, but I just want to raise it again because I ran into Robert Falcon-Willett this morning, and we had him on this show shortly after you gave that speech, and he said, you know, Justin Trudeau does give an F about Indigenous rights. Do you still believe that he doesn't?
I still do so, yeah, because what we are seeing is a continuation of what he has been doing for the last 6 years. So nothing has really changed in that regard. Even with Bill C-15, introducing it like this in the 11th hour could save them if there's this spring election to not going forward with it. I remember his speech at AFN General Assembly in December of 2015 after he got elected. This is one of the key promises he made to the chiefs. He got a standing ovation when he said that, and still to this day we haven't achieved it yet.
Just off camera there in the break we were talking about Governor General, and you know, there has been a lot of discussion. There was last time whether or not there should be an Indigenous person as the next Governor General. We're kind of short on time here, but do you think that the next Governor General should be an Indigenous person?
I think it would serve some purposes. I mean, I used certainly my position to call on the Queen to implement and honor treaties in this country. I sent back my medal that she sent me for her Jubilee celebrations with a letter saying, until you honor treaties in this country, I cannot accept this medal. She never responded to that letter from me, and I hold the same positions as back then on these matters.
Well, Romeo, it's a real pleasure to have you join us this week, and we thank you for that and for all the work that you've done over the years.
Pleasure. Thank you very much for having me.
And that is all the time we have for this week. You can catch up on any episodes you may have missed by visiting our website, aptnnews.ca. And you can find this and all previous episodes as a podcast at aptnnews.ca/face-to-face podcast. I'm Dennis Ward. Thanks for tuning in. Have a great night. We'll see you back here next week.